Keep your eyes out for Riley v. Bondi, June 26, 2025. Essentially, the Supreme Court said that the 30-day petition for review deadline post final order of removal is a claims processing rule, not jurisdictional. That means it can be extended and equitably told if the facts are there, it would seem. And it means that oil can waive it. They need not assert it. So that is a decently big deal. But on the other hand, for the FARO context, where ICE expeditiously orders someone removed, the 30 days of petition for review begins with the FARO and not when withholding of removal and Convention Against Torture Protection is denied in withholding only proceedings that follow. So that's a giant trap.
What's
seems
FARO?
Inequitable, but it's a final administrative. It's what ICE does when they expeditiously remove someone. ICE says the final administrative review order. ICE says, hello, green card holder. We think your conviction's an aggravated felony. You have 10 days to prove to us, ICE, that it's not. How often is ICE going to disagree with itself? So you get a FARO 10 days later, which is the final order of removal, instead of putting you in removal proceedings, even though, for example, you might be an LPR. I believe you can get a FARO as an LPR. It's the expansion of expedited removal that seems permitted by the statute, by RIRA, that just hasn't ever been used. But Trump and Stephen Miller are trying to maximize immigration law to the maximum extent possible, even sometimes beyond what seems permissible. They issue a FARO, and then you're gone, unless you can pass your reasonable fear interview and are placed in withholding only proceedings before an immigration judge. So you can't even readjust status, for example, because you're in withholding only proceedings.
Wow.
Withholding only proceedings, then, assuming you have this fear, are going to take a long time. Like to bring your claim, to get a decision. They're complicated. Supreme Court just said is you need to petition for review to the circuit after the FARO is issued, even though you're litigating withholding only proceedings at the same time, it would seem. Because if you don't, you're not going to be able to petition for review of the denial of withholding of removal and CAT at the end of it. It's very complicated.
Well, to add insult to injury, I just got done ChatGPTing the new big beautiful bill, quote unquote. They're going to have long-term detention for people in that situation. It's going to hold on to them for years until the court pays.
Oh, they're giving them billions of dollars.
Prison complex just as a giveaway. It's insane.